I apologize for what happened.
Well, what happened
The
that
deceased
you're apologizing
the
for?
deceased was my best friend.
I know, what did you have to do with his death?
Nothing.
All right. You just heard what he said. I had nothing to do with his death. You were indicted by a grand jury for the first degree felony of murder. You entered a plea of guilty to the lesser included second degree felony of manslaughter. A pre-sentence report has been ordered. Have the parties had an opportunity to review the pre-sentence report? Any corrections or changes to it, state
None from the state, Judge.
or defense?
We have, Judge, and we do not have any changes or corrections.
Made a part of the record for all purposes. The agreement is a cap of 15 years, I believe, correct?
Yes, Judge.
So you are looking at no less than 2 nor more than 15 years confinement in prison. I don't believe regular probation is an option.
That's correct, Judge.
Deferred can be.
Yes, Judge.
There are some things I highlighted here that I'd like the parties to address during this hearing, and the defendant may want to if he wishes. Go ahead, state if you want to go first, or you can go last.
I'd like to go last, Judge.
All right, defense, go ahead.
Judge, we're asking the court to consider deferred probation in this case for a couple of reasons. One is Mr. Moss is not even though he did engage in a fight with the decedent prior to the shooting, he is not the person who shot anyone. I don't think that's anyone's contention, but he was obviously a participant in this episode. Secondly, though, Judge, he has very limited criminal history. In fact, just has a possession of marijuana out of Smith County, but other than that, has little or no criminal history. And then, additionally, Judge, he's been in custody now. I want to say for almost 5 years, if not at 5 years, on this charge. And so, that's a significant amount of time under his belt, so to speak.
Well, this has occurred on February 17th, 2022.
Well,
The most he can have is 4 years.
4 years. Either way, he's been in custody since within a few days of the shooting, Judge. So I miscalculated that. I apologize to the court. But for 4 years, he's been in custody on this, and it seems to me it would be logical for the court to consider supervising him over the course of that 10 years of deferred adjudication and trying to help him get on the right track with his life and making better choices and things of that nature, as opposed to merely just giving him a prison sentence and letting that be the result. So we're asking the court to give consideration to that option, which again would, if he were to violate it, we've talked about it very thoroughly. If he were to violate his probation, he understands the severity of the consequences. He understands that the 15 years in the cap would go away, and instead he would be facing up to the full amount, which would be 20 years in this case, Judge.
Right. So I'm going to provide a little background so we can put this in perspective, Judge. There's 3 individuals that were charged with this offense. Specifically, Jacoby Broussard took a plea bargain agreement of a cap of 30 years to the murder offense. He was pled on October 6th of 2025. He came back on his sentencing on December 1st, and he received 30 years. It was at that time as well that we moved one of the other cases, Arthur Small, who in my opinion had less involvement than Mr. Moss. He received a plea for manslaughter and accepted a sentence of 8 years TDC, and that was subject to his testimony that was going to be offered against Mr. Broussard and Mr. Moss that directly contradicts what the defendant's version on page 1 Mr. Moss, we fashioned an agreement with him to allow him to plead to manslaughter as opposed to murder, again, because of not being the shooter at the time as far as the state's understanding of the evidence, but the fact that he was actively involved, participated in this, and again, specifically, what's highlighted on page 1 is that he was there, he observed it, and I know Your Honor's read the statements of the interested parties. Just the fact that someone could walk away from that and not do anything and then really stand here and ask you for probation is, I understand why they do, but it's just not warranted. When we look here at things from a perspective, the sentence that we gave Mr. Broussard was proper. The sentence that Mr. Small received is proper. It's appropriate that Mr. Moss receive a sentence somewhere between the 30 and the 8 years. To give him
Between what?
30 and 8. Mr. Small received an 8-year sentence. Mr. Broussard received a 30-year sentence. Mr. Moss can receive anywhere up to 15 years. And I'm just telling the court how I fashioned this agreement. There was a 4th individual that was immediately came forward and was not present at, not actively involved, and purposely identified all these individuals, and that's the reason why he went uncharged as far as these facts and circumstances are concerned. But to lessen the punishment for Mr. Moss would be highly inappropriate in this lawyer's opinion. I do agree that Mr. Moss has been in custody for the sum of approximately 4 years. I agree that he has a limited history involving this situation, but his lack really of accepting any kind of responsibility for this and a lack of remorse about what happened doesn't warrant the sentence that they're asking. I feel that 15 years is appropriate, Judge.
Okay. Go ahead. Anything you want to say?
No, Judge, I think,
Okay.
I think my only disagreement with him is about what the outcome should be. I think that the court has an opportunity here to address this young man's challenges and issues. And, if the court does see fit to give him 15 years, theoretically, he would be eligible for parole in 3 years and, would just be out versus being on the court's supervision for an extended period of time, a much more extended period of time, and all the while having the ability, as the court is well aware, to put him back in prison for an even further extended period of time based on his performance. So I'm asking the court to consider it. I understand what the sentences were for the other people involved, but I think the court can by its verdict can supervise this person, and by its ruling can supervise this person, and be as effective or even more effective than just a plain prison sentence.
One last thing I forgot to mention to Your Honor is when this was set on November 13th, it was on the trial docket. It was at that time that Mr. Moss learned that in addition to Small testifying against him, that Broussard was prepared to testify against him. So all the individuals there were about to come into the courtroom and set forth his actions. And it's only then, in my opinion, when his feet were on fire that we entered into this agreement. So we never fault somebody for waiting, but it is a fact that I wanted to share with the court.
I'm kind of funny about the presumption of innocence.
Yes, sir.
I do too, Judge.
I wrote an article on that one.
Yes, Judge.
And it's the lead article, by the way.
To be fair, I mean, we made decisions for a variety of reasons. Those people would have been subject to cross-examination, and we can see what we would have landed. But he's chosen to accept responsibility for his.
That's what this is all about.
Yes, Judge.
the circumstances of the crime, criminal history, those are the equations. Those are the factors that go into the equation of determining a sentence. You pleaded guilty not to the indictment of murder, but to the lesser included offense of manslaughter.
Yes, sir.
Okay. Did you want to say anything to the court?
No, sir.
Because there's a big gap problem here. The pre-sentence report is made a part of the record here without objection. I want to know what you did, because I can't understand it. It's not clear at all. You admitted, you pleaded guilty under oath to recklessly causing the death of an individual. I want you to explain to me or anybody what you did to recklessly cause the death, because according to this pre-sentence report, you didn't do a thing, which doesn't amount to culpability. Anything you want to say? Or I thought you were complete. Go ahead.
Well, I want to
add anything else?
I'm always concerned about questions like that for my clients, but
Yeah.
I think the answer here is goes back to the rule of parties. So we make a calculation about pleading guilty, not just based on the
Okay,
language of
go
the
into the,
indictment.
tell me how that connects him. That he just wasn't in the same area code. What was his connection with the party?
Well, Judge, he started the fight or got involved in the fight that started this entire process. I mean, his decisions to participate in the fight that ultimately led to the death of the decedent, even though it was someone else who did the shooting, he was there and was an active participant. And so, again, that's what the eyewitness says. It's what the other people involved.
Where's the evidence in the history of the reports and all that show where the defendant was at the time of the death? Is there anything you can?
There's statements from Arthur Small from the beginning that he was involved as an individual that got out of the car when Jacoby Broussard shot him. And that's also confirmed from the uncharged conspirator, Ladarius Stevenson. So all that's from the onset, Judge.
And the defendant has nothing more to say, right?
Yes, Judge, that's it.
Okay. All right. Anything else?
No, Your Honor.
If not, your last chance, because I'm about to proceed with the rendering of punishment. Okay. It's your call.
I just want to say that I apologize for what happened.
Well, what happened
The
that
deceased
you're apologizing
the
for?
deceased was my best friend.
I know. What did you have to do with his death?
Nothing. That day I was called to go feed.
All right. All right. You just heard what he said. I had nothing to do with his death.
Judge, he is a party to this offense.
Sir, I know that. I know what he's saying. But how can he say, I plead guilty and I had nothing to do with it? Can you fix that in the record? Because it's a problem.
I understand, Judge. Again, this is why I try not to encourage my clients to have conversations with the court like this.
But no, it's trying to place a square peg in a round hole. It's not fitting.
Judge, the answer again is he was actively involved in a fight with a person that was his friend, but ultimately was the decedent at the hands of another person, Mr. Broussard. And he was there. They were all at the stables. They were there. But when he says nothing, he means he wasn't the person that pulls out the gun and shot anybody. He didn't pull out the gun. He didn't produce the gun. He didn't hide the gun. Well, Judge, he was involved in the fight that led to the altercation that led to the decedent's death.
But I thought he
only
left
one
and
person
separated himself from that.
Well,
before the event.
I don't think it's before the event, Judge. I don't think that would
Well,
not be the evidence at trial. And
Well, that's not what he just said. That's not what this says. If Shortly didn't, he had no idea who shot and killed him, found out the next day. Interviewed, and we got him fined, however, he left shortly after and did not return. I mean, I'm not a dummy. I mean, this doesn't add up to being present at the time of the event. But he pleaded guilty. All right. Anything else?
No, Judge.
Anything else from anybody?
Okay.
All right. Here, Mr. Moss, you have pleaded guilty to this lesser included offense of the second degree of manslaughter voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted at the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this second degree felony of manslaughter. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 15 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. You understand what has happened today, sir?
Yes, sir.
You will be given credit for all time you have served in accordance with this place. Anything else to add by anybody?
No, Judge.
All right,
Thank you.
that is all.
Under Texas Penal Code, Section 19.04, this case involved a second-degree felony manslaughter conviction in Jefferson County, Texas. The offense carries a statutory punishment range of 2 to 20 years of confinement under Texas Penal Code Section 12.33. The defendant, Charles Ray Moss III, entered a negotiated guilty plea to the lesser-included offense of manslaughter after originally being indicted for murder. The court conducted all required statutory admonishments and found the plea to be knowing, voluntary, and intelligent, supported by sufficient evidence to sustain a conviction beyond a reasonable doubt. Pursuant to Texas Code of Criminal Procedure, Article 42.054, the court entered an affirmative deadly weapon finding. Identifying a firearm, this finding carries mandatory parole consequences, requiring the defendant to serve 1/2 of the sentence before becoming eligible for parole consideration. In accordance with the plea agreement, the court imposed a sentence of 15 years in the institutional division of the Texas Department of Criminal Justice. No probation or deferred adjudication was legally available, given the nature of the offense and the negotiated disposition. The court ordered credit for all time previously served, as calculated by the jail and the Department of Criminal Justice. With the acceptance of the plea and waiver of appellate rights, the judgment is final at the trial court level.